If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurdy confirmed that Mr. Bradley, his text messages were accurate in court testimony, but that fact was accurate. The motion is accurate. And so also, I do want to point out, there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand.
We ain't here. Mr. Ma'am in the building.
Keeping cash on hand in and of itself is not a problem. When you're a public
Final
official
arguments.
and you're required to keep track of gifts,
Already starting off terribly.
then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts. None of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what
But
we
does
know
the
about.
lack of evidence fall on the state? Does the lack of evidence fall on the state?
The judge is not filling them. The judge is not filling them.
Yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
Appreciate the court's time.
Nah, you ain't missed too much. That was just the first argument. It started not too long ago. They have so many people on the defense that's giving their what's the name? They argument.
Good afternoon, Your Honor.
You know, they moving through it. So yeah, we still at the beginning.
I'm going to speak to what I would call a
Midas touch
subset
started
of
early.
forensic misconduct. And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place under the subset of forensic misconduct.
Okay, so now they're not even saying it's conflict of interest. Now
Roman's
they're saying
counsel,
forensic
Ms.
misconduct.
Merchant, filed
Shout out to Emmanuel. Shout out to Peaches.
on January 8th, her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, DA Willis took it upon herself to go to a historic Black church in Atlanta, having not responded at all to the motion of Ms. Merchant's client, Roman. And she made what we've now called the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech was. It was videoed. It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was Black, without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was Black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant.
This hearing is supposed to be about the conflict of interest of
full opportunity
They can't prove
to the
that. So they're talking about
defendants.
everything else.
And then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion.
But the fact that y'all
Now,
smearing her
that was a
personal life
violation
in
of
the
the
public.
professional rules of conduct. It was a violation of 3.8 G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the
they
matter.
reaching.
Instead, she misstated what the
Now they making it
was,
about the
took
church.
advantage of the opportunity.
Because they could not prove the
An
money
ethical
thing.
violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can
Y'all
you think
have
of
been
anything more that would
That's crazy.
heighten public condemnation of the defendant?
They have been
than
literally
alleging that
tearing down this
defense
woman's
counsel
personal
and the
life in
defendants
public.
Were making their motion based
Come
on
on
race
now.
and religion. That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So
This
then
is
what we get
forensic
from the
misconduct.
state
Wow.
is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021. And that's on page 7. So that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade, Ms. Willis testify to the same thing under oath. Now, Ms. Yerti says it began in 2019. Why would
And
she
didn't
know?
provide no more
No,
information.
she would know because she was a former friend. I know the state's going to get up here and say, you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor for the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And
Both
then you also have
Wait, we talking ethics?
8.4.
When this whole
of
thing is
professional
about this
rules, it
woman's
says
sex life, we
it's a
talking
violation
ethics?
of the Georgia rules of professional conduct.
Bro, I'm
for
telling
lawyer
you, white
two,
folk know how to do
and that's
hypocrisy
A4,
in a way
engage in
that is
professional
crazy.
Conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the
Oh,
evidence in this
boy.
case about their truthfulness.
Y'all heard that.
Legitimate concern.
He says you
about
don't have to
truthfulness,
find that they lied.
which
He's
equates
admitting
to
that they
an
have no concrete
appearance
proof that they
of
lied.
impropriety.
Come on now.
Because once you have the appearance of impropriety under forensic misconduct, The law in Georgia is clear. That's enough to disqualify.
Oh boy.
So why
it's no
should you
longer
find there's a concern
the conflict of interest.
with their truth?
It's the forensic. It's the
ERT is the
forensic
first one.
misconduct that
You have that
causes
testimony.
an assumed
But then we
conflict
go
of interest. Stop playing.
to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says
Bradley
that
didn't
on
seem
January the 5th,
to be a credible witness.
2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like, just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him?
Keyword,
Bradley,
do you think?
Who we now know from Defense Exhibit 39 has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says,
Gossiping ass
absolutely.
nigga.
Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then, unprompted, says this. And unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate
But
whatever
they
one would
can't
call it,
find
to say
anybody
it was
that's
like.
not
And then
disgruntled with these people.
Mr. Bradley say they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant says, that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and relief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong, other than magistrate court municipal. Now we have that, and it's in evidence. And what does Bradley do? He knows that he's put himself in a position
What position is
that
that?
if he testifies truthfully on the witness stand,
What is that?
Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied.
But why is he
So what
not
does
being
Bradley
truthful?
do? Look, you were an assistant U.S. attorney. It works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions.
Why?
No recollection.
Why?
He couldn't remember. It
Why?
was speculation.
Why?
Anything he could possibly say that would cause, Your Honor, not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies. And the truth is in Defense Exhibit 26.
And so if we take that view that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached. Perhaps we have some kind of core that you could point back to and say, that's the time he was telling the truth. In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than just a assertion outright? Absolutely. Usually, if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, either the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander.
No.
If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors.
But the standard for prosecutors
when the ethical violations
is higher.
deal with truthfulness,
This has already been
candor to the
established.
court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? District attorney signs every indictment assigned to this courtroom. Does that mean she's off every case?
No, it would be when
If I found that she's untruthful, is that what you're kind of suggesting, though?
you don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful.
That's
You don't have
crazy.
to make a finding of fact
He's
that they
literally-
lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness.
That's not a finding
And once
of
you
fact. That's an assumption.
find that, then you can apply Registe and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely.
But
they
you're
could have
not-
testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense,
But that's
that
not-
dishonesty,
that's
that
their
constitutes
argument. You're
a violation
assuming-
of their ethical responsibilities. This is not
Right
signing
now,
a-
he's assuming
not filing
their
a
guilt.
pleading
So he's
in
saying
which
because
both
we
sides
assume that
have
they
their own
lied,
position.
because they could have said
This
something
is a
else. They
requirement
didn't say something else
that
because they're
every
saying they're
witness
not
has
lying.
to tell the truth under oath. And if they don't tell the truth, or there's a significant concern about their credibility, then they're violating their ethical rules.
But the
And as
concern of
anyone will tell
credibility
you,
is
as Your
with
Honor
old
already
boy,
knew
is
from
with
when you
Terrence
were a
Bradley.
prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving what I suggest to you is untruthful testimony based on what Yerty has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. Then Your Honor fortunately went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley,
That means Bradley can't be
that
trusted
what he
either way.
said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. That Yerty says that. And now, without getting into any detail, the cell phone records The cell phone records show
Okay, now we
that
talking
during
about the
that
cell phone
period of
record.
time from, let's say, April 1, 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Miss Willis was staying
In the area. Not in her home.
More important is
the
there are two
records show
occasions,
he was in the area.
and the state has not
Stop.
challenged those. There are two occasions where the records reflect that it appears Mr. Wade spent the night.
The state did challenge those.
The
They
state
said,
may say,
yeah,
we
they
don't
bullshitting.
accept that. But they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerte had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35,
Okay.
but never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No,
Okay.
it's not determined.
The overnight rate might raise some more concerns. Understood.
It does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestat, because that is suggestive that they were not being honest to the court.
Again, another suggestion, no proof.
How much time have I used? Too much. Have I?
I'm letting them use the hook. So, suggestive, again, raising issues. I'm wondering about burden. Is it we're
Thank
dealing with a
you.
preponderance standard?
We are
Thank you.
dealing with a preponderance standard, and it's our burden.
Yeah.
No question about that.
So does
But-
suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerte says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, factual findings are yours, but the law allows you to do that.
Wow.
You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gillen's going to argue.
Yeah.
Before I
So
let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says
No.
falls into that box?
No, I'm saying that
Improper,
that
obviously.
forensic misconduct as a subset of that would include violations, ethical violations, which impact the ability of the defendant to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these two prosecutors, are acting in good faith in their own conduct.
they not acting in good faith.
Same idea.
though. The
dealing
defense
with,
is
as
not
I said,
acting in
defense
good
counsel in the two cases I mentioned. Ethical violations can give rise to disqualification, and I said here.
All right. Thank you, Mr. Sano.
Thank you.
faith. Yeah. See, what he's saying is that
Where's the
we
shot
haven't-
clock when you need it?
We haven't proven what we're trying to prove.
Your Honor, I
but
want to.
you can still
address
agree with
very
us if you
directly
want to.
here.
That's bullshit.
What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case, in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down, wrote out her speech, wrote out her plan. Who
They've
sat
completely
down for,
abandoned
whether it's
the
six,
money,
two,
the
three, or
money
six
shit.
times with the editors.
Like that does
of
not
Find Me
matter
the
anymore.
Votes,
It's all
and
now. It's
told
all
and
about
got
she
her
did
message
this
out
one.
about
Yeah, after
this case.
Come on now.
Before it was supposed to be tried.
Y'all can't
in
stand
this
on y'all
courtroom.
original shit. That's why
And
y'all doing
so
this.
that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So
Now-
we have a pattern of public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying a particular defendant is guilty, and it even denied it, right? So, have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one
They
response
pulling out
to
they
an
law school
inquiry. The court
experience,
found
boy.
it was
Not
improper,
answering the
but did
question.
not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for two reasons. Drew up a plan for two reasons.
First,
and
we
what
supposed
she
to be
did,
talking about her.
reminds me of what the
we supposed to be talking about
and
her
that is
financially
that free trials
benefiting,
create
all
more
of this.
problems for defendant.
They creating
Indeed,
controversy
more
for the sake of
harmful than
controversy.
Publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So
Oh, boy.
what do we have, and what did this prosecutor do? What she chose to do is sort of what
This is
was
wild.
criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are
Who gonna talk
are
about
not
the
like
money?
elections to be won
Who
through
gonna
the
talk
use
about
of
the money?
meeting halls,
All they said
or
is
the
that
newspaper. That's exactly
that there's no paper
what
trail
we
for the
have
money
here.
that she paid
What
back.
we have
Show
is
the
a
proof
deflection.
of the conflict of interest.
What this is all about is it's more insidious than just making the comments that she's made. It's a deflection. What she chose to do
That's a
was to say,
deflection.
wow.
Wow.
Okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when
This is rich. I'm
Burchett
telling you.
filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. Look at I'm sure the
How
court
is
has-
this not
when
a
you look at that
deflection? The
video,
nerve.
It's in evidence of her speech at church.
The
She has
caucasity.
written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that case and say, there's been an allegation that I had a romantic relationship with Mr. Wade. And ladies and gentlemen of this congregation, it's true. She didn't do that.
Why?
She
So
chose to deflect and to do two things that are reprehensible for
Nah,
any
y'all
lawyer,
racist.
but
Y'all
particularly
racist,
for
for sure, for
prosecutor.
sure.
She chose to pull out the race card and the
Wow.
God card.
Wow.
That's what she did.
So
she
two
wrote it
attorneys
out.
getting up here
She
talking
went
about
on
her
to
speech.
deflect away from the allegations.
Only one attorney didn't
in
brought up the
Wade
bread.
motion,
This is the second
and she
attorney to
said-
talk
she's
about
saying,
that's bringing up
why,
this church
in
speech.
her talk, public discussion with God, why are they only attacking one in reference to Mr. Wade?
Yeah, in terms of
And
his
then she
payment,
goes
in terms
on
of
to
how much
say,
he's paid.
God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community,
Oh, boy.
she would have said, I had a
If
relationship
she would have been
with him.
truthful with that, yo.
Good, bad, forgive me, whatever. That's what she should have said.
What does that have
But
to
she
do
chose to
with
deflect
her
and
being
say
disqualified for
them,
financially
the
benefiting?
reference to them and the others and they.
Yeah,
It's
y'all.
obviously a reference to the
Yes.
by Ms. Merchant.
Trump and his
They,
racist ass team.
choose
Yeah.
to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not
She's
necessarily
responding
in that
to
audience
y'all
in that
saying
church.
he was
The listener is
unqualified.
at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And
Ain't nobody, that shit been
not only
passed.
the race card, but also in bringing in the religious matter. This is exactly what Hammonds v. State and our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God is saying, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others
Oh my
going
God,
after
bro. This is
the
what
black
it looks
man?
like
Well, the
when
answer
you
is very
don't
simple,
have
as
any
we said in our
solid
brief.
evidence.
We didn't mention Mrs. Cross, the white female.
This is what
the
happens
white
when
male,
you
because there was
don't have
absolutely
any
no
solid
evidence.
evidence.
There is no evidence of a
Okay?
personal romantic relationship.
This whole thing
with him
started because
in
it was
which
supposed to
he
be a financial
obtained,
gain.
these
They haven't
benefits.
shown that
That's
at all.
the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward, and she talks about a planned interviews time and time again with authors of a book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that.
So we're gonna
those
ignore
people
the fact that
calling
she's
me
being
up
harassed.
and making those claims or those horrible are
So-
really people on their side of the fence.
They are.
That's what she's doing.
They're mad
And
at her
there's no
for
reason,
prosecuting
Your Honor,
Donald
ever
Trump.
for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes, but then they
This is wild.
what really happened here
Like
is
the-
this
the
hiding in the
caucasity.
relationship.
The
Because in
hypocrisy.
hiding in the relationship, they have done
He goes
such
from the
a good
book
job.
to hiding
Mr.
the
Wade,
relationship.
filed false documents in his divorce case when on May the 23rd, May of 2023, talking about
This
have you
is
ever had
crazy.
sexual relations with a person during the course of the marriage, or including
You ignore the death
period of
threats from
separation.
racists
He's still
to
married.
protect your client.
He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not, on any occasions, he's entertained or been entertained
Yeah.
by someone, for a woman, a member of the opposite sex, in this case, a woman, from the date of the marriage to the present, talking about place and time and all that. What is he?
Yeah, I'm
answer?
telling
None.
you, if the
Why does he
judge
do that?
lets them get away
He
with
does
this,
that because he
I'm-
doesn't
it's-
want to tell about
Yeah.
the relationship
I mean, this is-
that he
this
has
is
with
Georgia.
Miss Willis and the benefits.
But if the
that
judge
he
lets
has
them get
gotten
away with
and that he
this,
gave to her.
they've abandoned their
And
initial
what,
argument.
What these answers are
They've abandoned their initial
absolutely
argument.
reprehensible that a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do?
Y'all hit that like button.
Miss Willis do. Miss Willis, on her financial report, on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade. All the
What
trips,
benefits?
all the entertainment, all the 3 nights in the luxury suite in Aruba. All of that. None of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present and the court gave me one back. The court has to fill out a form whether you got a Christmas present from anybody. You say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're reports. And because they're false, what they had to do is they had to say, uh-oh, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important, and frankly, I do too. Because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught.
All right, I'm because he ain't really saying shit. So where I want to chime in is this. This is what makes this shit racist. These white men have been fucking on their subordinates for years, taking them trips for years, like having romantic relationships for years. That's why even case law says that they have the ability that you can have two opposing attorneys on two different sides that are married. Because the case law in Georgia says that the expectation is that relationship, lawyers are professional enough to make sure that their personal lives don't blend. And this is Georgia case law that's being wholly ignored. That's what makes it racist. Because why does that standard not apply to Fani Willis in this case? Without y'all criminalizing networking that y'all do all the time. That's crazy.
Paid him back in cash. Show us your receipts. Where did you take cash out of the bank? Ever? Oh, I don't have any. Well, show us the deposits that he had. Well, never. We don't have any. What we have here.
Even if you take money out the bank, it's not going to say you took out this for Fani Willis, bro. That's crazy.
And overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, gave him money, it evaporated. I don't know where it came from.
Bro,
and he
it'd be
doesn't know what he
crazy
did
if she
with
get
it.
removed from
Just
this case for
please
this.
trust us and believe us, because it's our only way out of the trap that they set for themselves. These people, sadly, and I hate to say, I was a former, as the court knows, I was a prosecutor for about 3.5 million years, it seems, in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need
Systematic
to go.
misconduct.
Thank
Wow.
you.
Systematic misconduct. Even though Georgia case law pretty says that two people that are dating can work on the same case.
Your Honor, I'm going to
Interesting.
cover a few factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the
Wow.
backs of the defendants
On
in
a
this
Carnival
case,
cruise.
funded by the taxpayers of Fulton County and the
All
state of
right,
Georgia.
now he about to get
With
into
the
it. Let's
money,
see. Carnival cruises, living like
Mr. Wade,
rich and famous.
through the contract that Ms. Willis got him.
Let's see.
That money flow, that is the personal interest that you asked about. She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment, and how they conducted it. And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include
That's lifestyles of the rich
the
and
various
famous.
dinners, the day trips that both Wade and Willis admitted to. So that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurdy, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019.
She didn't lay out a
saw them
time
kissing,
frame.
She saw them hugging.
She literally
Now,
just said that it started. That
whether
that's
or
what-
not they
like
had
it started
sex
before.
January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that Wade and Willis just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. I don't even think love-struck teenagers communicate that much.
They communicate
On November
more.
29th and November 30th.
They communicate more.
Phone call from Miss Willis, between Miss Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling
See,
down.
we getting back to the. I thought
from
we supposed to be
where
talking about
Mr.
the money.
Wade lives. It ends up where Miss Willis is staying.
I thought we were supposed to be talking about the
and
money.
was there until roughly 4:55
But we back to
a.m.
when they were spending time together.
none of
Niggas
the
have not
excuses,
proved the relationship started
the
prior.
explanations
Their
that
evidence has been
Mr.
trashed, and
Wade
none of it's been
gave.
considered.
Experience.
None of it's been
Going
considered
to
credible.
dinner, going to the airport. None of that explains that. I'm pretty sure the Porsche experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night, right after he talked to Miss Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said.
None of it's subjective.
When you look at Miss Yurdy, again,
Yurdy,
she unequivocally said
disgruntled employee.
that relationship began in 2019.
Yurdy,
She
disgruntled
saw
employee.
physical
Next.
evidence of a romantic relationship.
Disgruntled employee.
Mr.
Next.
Bradley,
A gossiper.
in the text messages,
A gossiper.
which are substantive evidence, said that
Y'all
relationship
can't even get him to
began in
corroborate his own
2019.
text messages.
Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment. You asked, well, and Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has
17,000
told
is a
us,
lifetime of
has
rich and
told
famous.
Mrs.
Come on,
Willis
lifestyles
what
of the
the
rich and famous.
materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her excuse, or I'm sorry, her explanation, well, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh.
This ain't a money
I just
laundering
gave
trial.
cash. I have no records for it. I have no
This
source
is not
for
a
it.
money laundering
The
trial.
only thing that she could say that was the source for the money said she was down to $500 to $1,000. The only explanation she have is, well, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No.
Nah,
Did
I
they
wouldn't
bring her
either.
bank accounts in? No. Did they
No.
bring any
Because it's not going to show
documentary evidence
what,
in?
like, what the
No,
money
they
was
did
used
not.
for.
Why is that important, Judge? Yes, the burden is ours.
Hey, the state
But
better
under
eat this up,
OCGA,
man.
OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim.
So all of this stuff, when they saying
And
it's
that
in
is
your
something that
power
the
to do
state
so,
relies on regularly in criminal trials. And that is something that the court should rely on.
anytime they say that the court has the power to do so, this means that, well, if you find what we're saying persuasive, you can do this. They already know that they are not meeting the exact burden that's necessary to have her removed. That's why they keep saying, well, it's in your power, Judge, if you want to. Like, come on, bro.
Falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else?
See, they
that
all
defendants
talking about
were
the
guilty?
same shit. Yeah.
And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty.
Oh, God.
That is what she was saying. She is a
Yeah.
prosecutor. she's familiar with the U.S. v. Berger. Every single attorney that's ever
This
been a
shit is
prosecutor is
weak.
familiar with the dictates of that U.S. Supreme Court case.
Well,
That's
she didn't say it,
foul play.
Judge, but I think
That
she
is
said it.
improper.
Come on now.
And she violated
Come on now.
pretty much every tenet a prosecutor.
If the
must
judge
abide
falls
by
for this
to seek truth and
nonsense,
justice in a particular
throw the
case.
state away. Throw Georgia away. Straight up.
So, Judge, when you're looking at this, the uncontroverted evidence shows that they had
Of
a relationship
gossip.
prior.
Of
The
gossip.
uncontroverted evidence shows that Mr. Wade lavishly spent on Miss Willis.
Lavishly.
The uncontroverted evidence shows
He
that
trying.
the money that he was spending on Miss Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his
The man had money. To assume that the only money was that he spent was money that he got from this process is stupid. That's dumb.
Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance, but an actual conflict, then what Ms. Willis has done since then in this case creates an actual conflict. But
Boy, that's a
Again,
reach.
as prior counsel has stated, we only need to show the appearance of a conflict.
No,
And
you
we
don't.
have done that by a preponderance of the evidence. In fact, I believe we've shown an actual conflict. But nonetheless,
Hold
the
on, so
result should be
was it an
that
actual
Ms.
conflict or
Willis
was it appearance of
and her
conflict?
office should be disqualified from this case.
Come on now. Like if you
we
say
still
it,
have a few more minutes. I think Mr. Cromwell may have something to say.
did y'all
Thank
caught
you.
that, right? Y'all caught
you.
that. He said the evidence has shown an appearance of conflict, but I think we've shown an actual conflict. Which one is it?
Good afternoon, Your Honor.
Either you have an actual
Harry
conflict or
McDougall for Mr.
you're
Clark.
assuming the
I'm going to
appearance.
talk further about conflicts, and I'm going to assume the most difficult standard for us to meet with full conflict. But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first
White
occurrence
people
of that
talking
that I
about
can
not
find
being
is in the
biased.
State more than 100
Like
years
white
ago,
people
1915.
specifically in the
The
courts
most
talking about not
recent,
being
Would
biased
you
is
stay be
crazy.
State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties.
Y'all see Ashley Merchant
as
ain't took her
district
ass
attorney
up there,
and
right?
take
I
on
wonder
my
if they're gonna
lawful
let her speak.
compensation, So help me God.
I wonder if they're gonna let her speak.
The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs
But
your
y'all
independent
argument is
professional
financial.
judgment.
Y'all
And you
argument
see
is the
that in
financial
McLaughlin
benefit.
v. Payne. The court
Yo,
asked
these-
what was
they
the
literally
personal
talking
interest
out
for
both sides of their
purposes
mouth.
of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant.
Georgia
which
case law
list,
says a relationship doesn't
the
automatically
prosecutor's
mean it's a
personal,
conflict.
Political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What
But-
my colleagues have described as forensic misconduct is also cognizable as a conflict of interest
footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship.
Yo,
That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but
Let's hear it.
collectively, practically compelling.
6
First,
different.
the
Let's hear it.
financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or
Now they
complementary
making brand
pattern
new arguments.
of deceit and concealment of the relationship and the money.
That was
Fourth,
the first
the
2.
speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense
All of this shit
this
is the
motion
same
to
shit.
disqualify, especially the hearing.
Oh boy,
On the financial piece,
he gave no clear
court
conflict
asked
of
for a
interest. He's
limiting
making an
principle
assumption.
and
That's
asked about
crazy.
materiality. The limiting principle pairs the independent professional judgment of the lawyer that is applied routinely. We have a county
Bro,
code
if they able to
section
get away with
that
this,
flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 USC 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory
they all talking
based
about the
on
same
State
shit.
v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which she was previously
Political
chastised by
ambition.
Judge McBurney. And that's also present in this book. The inside book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book.
The glory of the book.
I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did.
She
She
did.
cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code, prohibited sources, which he was, there is no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false and that it is a false writing. That's an actual conflict of interest between her legal duty of disclosure, her legal duty of.
If the judge changes the standard for what this disqualification, I mean, because even when he said it, the judge specifically said, the judge specifically said that this hearing is to expose any financial benefit that Fani Willis received by hiring and dating Nathan Wade. They are not talking about that. They're kind of pointing it out. They're saying, "Oh, this happened," without showing no real proof. Their only argument is that she said she paid in cash, and we don't know if that's true or not. Yeah, if y'all don't know it's true or not, and y'all don't have any evidence to refute it, that's your problem. You failed.
investigation of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church.
Man, y'all gotta let that go.
Mr. Gillen talked about that.
Y'all gotta let that go.
To deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor.
If I gotta hear about this damn speech one more time.
And the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA.
Oh, my fault. Let me turn it up.
Predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation.
How was that an obstruction? Explain how that's an
prayer for
obstruction.
relief on page 11. She asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends.
It is, yeah. You are the
There's no
ones that are
sugarcoating.
deflecting.
Violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution.
Wow, they
to gain
talking
advantage
dirty,
for
boy.
herself and her boyfriend in her boyfriend's divorce.
They talking
violated
dirty.
her
And
public
but they got
duties.
nothing out of it.
Not to make that in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, to be absolutely clear, there is evidence that DA Willis derived any financial benefit from Mr. Wade. That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest.
This is crazy. This is crazy. Like you haven't described
The problem here is
you've
the
described
DA
the
cannot
scenario in a
distinguish
way that's
between her
beneficial.
personal
The
interests
facts
and
don't
ambitions
bear
on
what
the
you're
one hand,
saying.
and her public duties as a prosecutor on the
This
other. And
is an
apparently
interference.
Neither can anyone
That's
else in
crazy.
their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence.
Right.
This is a case study.
Right,
in
only
what
one. So
happens
the 6 things that
when
you named are
operate under a
pointless.
conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent
You,
if they were
you
not
want
disqualified.
you want an
If this is
irreparable
tolerated, we'll get more
irreparable
of it.
stain on the case.
This office is a global laughing
That's what you're
stock
trying
because
to
of their
do.
conduct.
Come on now. All of this gaslighting?
They should
Well-
be disqualified, and the case should be just.
Boo, that was terrible. Gaslighting,
There's
terrible.
not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had, 5 minutes for
Sure.
rebuttal?
That's fine.
All right, thank you, Your Honor.
All right. Let's take a quick 5 and we'll be back at 2:40-ish to hear from the state. Thank you.
All right, y'all. All right, let's talk about these arguments being made. All right. What the defense is doing is they're basing their arguments on the assumptions that they are making. None of what they want, none of the evidence that they presented bore out the way that they wanted it to. Old girl that they kept bringing up, her ex-friend, they ignored the fact that they are no longer friends because she was fired from Fani Willis's office. They ignored the fact that she could give them no details. She could give them no information or about when or where they had these connections or what conversation they had. She couldn't tell you where she seen them kissing. She couldn't tell you where she seen them hugging, but they was kissing and hugging. Literally, go back to day one of testimony. When they was asked you, well, can you give us a time? No, I can't. Can you give us a place? No, I can't. Can you tell me something? Can you tell us something that she said to confirm? No, I can't. All she could say is, yes, they were dating, and yes, I seen it. But outside of that, there was no other information that she provided. So they trying to overplay this yurty hand because she didn't do shit. She didn't bring anything productive other than saying what she wanted them to say. Then you got Terrence Bradley. The fact that they're trying to still use those text messages when he impeached himself. What the judge pointed out was, how are you telling me that we should believe the text messages, but we shouldn't believe his testimony? Which one is the lie? Which one is the lie? Did he lie about speculating, or is he lying about, or did he lie about, or did he exaggerate? Right? Was he gossiping in those text messages? That makes him an uncredible witness. He's not credible. He didn't even corroborate those same text messages. So even if the judge is going to sit there and say, well, you know, he's not credible, that means he ain't credible for either one of y'all. He doesn't prove, nor does he dismiss when the relationship started. That nigga's a wash. Terrence Bradley is a wash. And everybody can see the conversation that he was having with Ashley Merchant. Everybody can see what it is. He was hating. He had issue, so he was hating. That's all it was. These arguments are all based on conjecture. None of what they're saying is bearing out. That's why they're telling the judge, well, even if you don't we don't have the concrete proof, but think about it. Don't something seem off? Y'all telling me that y'all want the judge to dismiss this entire RICO case that got to do with stealing an election simply because there are people involved, and the people involved that are untrustworthy was the people that was brought by the defense. Ashley Merchant showing those text messages and showing those conversations shows that the defense was using underhanded tactics in order to get Terrence Bradley on the stand. Remember, they even admitted that he didn't want to be there. They even admitted that he attempted to make sure when he was talking to Ashley Merchant that, yo, I don't want to be connected back to this. Why? Why would you rely on a witness that's telling you that I don't want this connected to me? That's because he's saying that shit. I know some of this, maybe a little bit or maybe not, right? And to be honest, even if the relationship started beforehand, they have not brought the proper proof to establish that. All they have done is brought witnesses that really could and should be called into question in terms of their own credibility. And then we just gonna ignore that they both disgruntled employees. Miss Yurdy was fired she resigned because she had bad performance, and the district and Fani Willis in her office was like, yo, this ain't working out. So instead of us embarrassing you, you can go ahead and resign. So of course she gonna feel away. Of course. Terrence Bradley was removed from the firm that he worked at with Nathan Wade because of sexual harassment. He was removed. They was asking him questions. They was asking him during his testimony, they was asking him questions, you know what I'm saying, about their friendship and about all of that. Yeah, and all of that shit ended. They were friends. So we supposed to find credibility in somebody like Ashley Merchant doing some snake shit and going to the friends to gossip to get information that you now gonna put in a filing. Emmanuel, I think it was Emmanuel said it earlier. This is like a bad Inquirer article going to trial, and that's exactly what's happening. That's exactly what's happening. And I don't put it past like this is Georgia, right? So I don't put it past them kind of this judge buying into it. You feel me? I'm curious to see how he responds to the state, because he definitely questions certain aspects, or called into question certain aspects of the defense's argument. I'm interested to see how he's gonna call into question arguments made by the state. I'm also curious as to I'll say I'm curious, but I have a pretty good idea on how the state is gonna respond to the money accusations, to the phone record. The phone record accusations is easy. The defense must not have read the response filing to the affidavit with the phone records. Fani Willis argued that her calendar shows that on dates that they were saying that Nathan Wade was at her house, she was actually doing shit for her office. A couple of the dates that she said that they said she was with Nathan Wade, she was actually visiting a crime scene at the site of a mass shooting. They not prepared. They not. Now again, I don't put nothing past Georgia. You know what I'm saying? And we coming back. I don't put nothing past Georgia. But at the end of the day, they have not presented a solid case as to her gaining financially. They spent more time talking about other things that they felt like was unethical than they did actually talking about the conflict of interest. All right, so let's bring it back. Let's see what the state got to say.
I just am trying to get to where I can share
Y'all
my
give me
screen.
just a second.
We need to
Gotta
add
make a
you as a
quick
host
run.
then.
Gotta make a
What's
quick run.
your profile name on the Zoom? Your screen name on the Zoom.
Adam Abadi.
All right, just making sure. Bear with us. Do you need it right away?
No, I can start without.
All right, floor is yours.
So good afternoon, Your Honor. Start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis, in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade. And once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge, that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to.
So, but wait, are you making an argument I should make inferences based? Now, these would be attorney-client privileges or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were fired, or excuse me, you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw or saw, excuse me, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share. Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon
Oh shit! I was
this
on mute. Shout out to Q.
article from
Hold on, let me turn
Cornell
it down,
scholarship reading. Or
So y'all correct me if I'm wrong. Appreciate it, Emmanuel. Correct me if I'm wrong, but don't he sound flustered? Like he sound like he kind of intimidated, or like the moment is getting to him. You know what I mean? Like he doesn't sound compelling. I think he's making the right argument, but he missing that ethos.
they have to show, and the actual conflict would be that Miss Willis received a financial benefit or gain and did it based or got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we before Your Honor. They were not able to provide any evidence as to, or to the contrary of Miss Willis and Miss Wade's assertions of when they began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing
he's just saying the same thing over again. Come on,
rights,
bro.
Their due process rights were at all affected by the relationship that began in March of 2022 with Miss Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Miss Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Miss Willis and the district attorney's office. And looking at
and look, he got to do better on his PowerPoint. 1 and 1. Come on, bro.
I think you're talking about, is this Ventura?
It's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced as they argued here today and in their filings.
This is like cringeworthy. I ain't gonna lie. It's very cringy for me.
The standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the.
Now, y'all know I judge debates. Well, I have in the past. I don't do it as much anymore. And so, like, this is kind of making me. It's like it's performance wise. Like, he's an attorney. He passed the bar. He working with this is one of the biggest cases in the world right now. But that's why it's just like from a performance standpoint, it's real novice-ish. Like, he sound young. Oh shit!
Now it's time for the last word with
224 Georgia, and I'm sorry, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is a case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court the sites are misleading, many of them are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language, the multiple cases, and kind of what I would say is misstates the law as it relates to what the law.
And don't say kinda, just say they misstate the law.
An elected district attorney and their office.
See, that's the difference between Trump's attorneys and this guy. Like, they were more forceful and definitive with their statements. They were much more definitive with their statements. Judge told him, just show me how, though.
Show you how.
So I think the first one they cited was battle versus the state. Certainly a conflict of interest or the appearance of impropriety can be the grounds of disqualification.
Well.
Oh, bro. Okay.
And there were a number of these cases that seem to exclusively rely on the appearance of impropriety.
Right.
Well, so they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. But they acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they all there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety.
As it relates to a prosecutor or a district attorney, yes, that is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you.
Why would you not be more prepared to explain that?
And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense
this nigga letting me
decided.
down,
What I
man.
would submit to the court and reading those cases that I found.
I hope
that
they got some more.
They kind of fell into 5 categories. That some that didn't concern disqualification at all, some that determined or
cite which
that were
cases?
about,
Why wouldn't you
divided
put
loyalty?
this
which
case is they cited
a
this and this does not
conflict that
concern
arises from representing a
yeah, I don't know what they
becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome. And then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction.
This is disappointing.
And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today.
Like the argument is solid. He's just not
MacGyver
doing a
has nothing
good
to
job
do,
of articulating it.
Has nothing related to the disqualification of anyone.
I mean, I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if they're more, all right, keep going.
Oh my God. Yeah. And then
So as it relates to one of the cases that was referenced here earlier, and is also
C-Dot, your boy coming off
some of
like
the
an
briefing,
amateur, man.
By defense counsel is
This case was too serious to put somebody like
Majestic
that
B State, which is
that
287
stumbles
Georgia,
like this to
542.
make these
And all of-
arguments, yo.
All of the cases that fall under this, what I would call category.
Everything has
about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has a form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example.
I don't know if it's just the
is dependent
or what it
on the
is,
outcome
but this is
of the case.
cringe
That's
worthy.
how, one is to show that there's a personal interest in the case. We
It's
have
just-
none of that here.
he
And I would
just
submit to the
talking
court, we have
disjointed.
absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
All right, let me explore this one a little bit. So in addition
I
to
knew this was
you're
coming.
saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about? Or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got officers is lying not to tell you about it because they want to win that motion to suppress. But maybe that doesn't affect the outcome because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would, I guess, be necessary and appropriate because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? Okay. But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because as Your Honor just said, since where an officer's lying or that where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied, and the evidence was
All right,
suppressed,
so what
knowing
he's
that they didn't have a good
trying to
faith basis
explain
go
to the
forward,
judge that the
affects
judge
ultimate outcome of the case.
has picked
So,
up on
I think it's
is the conflict of interest would have to arise if the outcome of the case led to more money for the prosecutor. So in this instance, we'll say a special ADA representing the DA's office had an impermissible conflict due in civil forfeiture proceedings because of their contingency fee arrangement, which means that them winning this case means that they get a benefit, they get paid out of it. You know what I'm saying? That would create an impermissible conflict of interest in terms of finances.
Getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required.
Okay. All right. Because now there's the confusion.
A series of cases.
Or not necessarily
Young,
confusion.
that was referenced by defense counsel as well as Nichols. These state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
Right. They would benefit
and
from.
What do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife. And generally when there is a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world? No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest, in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate.
I wish I was there. Oh God, I wish I was there.
I guess the representations
Hold
of
on.
defense counsel as it relates to the standard.
So the judge is asking about like the ethical behavior. The basis of their ethical behavior argument is that is from the perspective of the state is a mischaracterization of the facts. So in order for her to be seen as unethical, right, you would have to buy the state's representation of the church speech. You would have to buy the state's representation of the testimony from Nathan Wade. That's why they're using the unethical, position, right, to create that appearance of conflict based on the unethicality. You have to argue that the only reason they're making that argument is based on their misrepresentation of testimony, and then say what you know what I mean.
Those are the two
I don't know.
grounds
That's me though.
To be, I guess, all right, within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that there must be that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful. I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear.
Tab somebody in, man.
Relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should, as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of,
Not I guess.
disqualifying the
Don't
district
say
attorney
stuff like
unless
that,
an
bro.
actual
Speak
conflict of interest
definitively.
is what's found, Your Honor. And it can't be cured.
This is rusty.
So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that
Are y'all
what has to
finding
be
this
shown is
persuasive?
an actual conflict. If it's
Are y'all
speculation,
finding this persuasive?
Is there any qualifier there, though, that's in a post-conviction context?
So-
We're talking about, competent evidence, obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality: was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought. If you have any reactions.
Well, I think what Your Honor just said is pretty on point, in the sense that if it's found that I guess the trial court either applied the wrong standard or should
Oh
have
my
disqualified
God.
the district
I'm
attorney,
shocked
it leads to an automatic reversal.
by
like
how
you
weak
said, and
this
it goes
is.
back to the trial
I
court.
am shocked.
And I think that is very enlightening, in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety of the appearance of a conflict that would lead to
I mean, I guess what I'm getting
that.
at, I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same applies here with disqualification.
Well, and I would,
But I don't have the answer to that.
well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does
I'm
address
disappointed,
some of the
yo.
concerns as it relates to the standard as it is applied
I'm
post-conviction
disappointed.
versus pretrial during pretrial issues. And what I would say to the court,
He got the tools. His argumentation
Are
is
you
trash.
citing that
though.
in support? Because I didn't think the state was all that pleased with the analysis he
Like, what
Applied.
is this?
what I'm citing,
legal analysis that is.
I'm citing what you specifically referenced as to the standard that is to be applied pretrial.
This is
and
way too
post-trial,
serious
whether
for
it
this
makes a
type of-
difference. And what I would
Put-
say to
but
the court
this
is
type
the
of
answer is
showing.
no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor.
Yeah, this is.
What I can't do at the moment is point exactly to the page at the end of
Move on, bro.
the state's argument. I can give you the page
Come on.
number as it relates to Judge McBurney's order.
I think I know what you're talking. The footnote where he references the appearance standard.
Yeah.
I mean, you got time, but move on. Like,
Further, in Lamb 267, Georgia 41, on page 42, it's a 1996 case where the court says Nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same, whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged.
This is called debating down. That's what this is called.
So in the case that's been referenced, all parties here today, Whitworth v. State 275 Georgia, Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands.
Thank you.
I think it was conceded that that balance could run in one way or in the district attorney's favor.
It's a bad look.
Is that contested?
It's a bad look.
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
Like the judge is literally trying to get him on track.
They were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other. And if that wasn't done, cash was exchanged in order to equal the cost paid by either one of the parties.
Right. But that's a facted issue, whether it was, split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the attorney.
Hold on.
That were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house. That was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in
Fani going,
Whitworth,
they about to get disqualified.
Again, submit to the court requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
Man, Regular Joe, this is the state's final state and final arguments, and it's ass. It's ass. It's ass.
So in State v.
and
Sutherland, which is 190 Georgia Appeal 606, it's a 1989
why are
case.
you?
It says officers should
He
see
not
no
okay.
unfair advantages.
The judge has literally said that we're past the speculation. Why are you getting back into the actual conflicts of interest? The judge wants you to address the facts now. Respond to the facts of what's being made. I get, yeah, you say, hey, you respond to what the judge is saying, and then you recognize that the judge wants you to respond to more of the facts. Like, this is crazy. This is very disappointing. Straight up.
In the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because there's always going to appear bias as it relates to getting justice for the victims, or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of.
And then these gaps, like this. Come on, okay, bro. Like,
So I want to move into, I guess, the evidence
Oh,
that
boy.
Your Honor
this is hard to watch, y'all.
saw and heard during
This is
the
very
last
hard to
couple
watch.
of days.
Fani could
three total
lose.
days
Like,
of
Fani could be
testimony,
disqualified because
as
of
it
this
relates
shit.
to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here, sitting before the court, that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law. And what I would submit to the court is that Miss Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
I would agree with the court. It's not an evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But it's clear that what was represented as to why she would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify. That
So
she shouldn't be
then
compelled
under
by the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive
So
arise?
she was fighting so hard to avoid the, if we're going down that road you propose, she was fighting to have not to come in here and testify at all. And then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it as is ultimately when she was forced to
Motive.
testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross, whether
Where is she? Where's Ms.
resigned or
Cross?
forced to leave, she was fired. She came out and said she was given the choice, you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired, and when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would.
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that.
Yeah, because
Well,
oh damn, bro.
I don't know anybody who wants to testify before a court.
This is bad. So y'all hear this. What the judge is essentially pointing out is like these things kind of conflict. So even relying on, like, you can rely on the inconsistencies, but like trying to be like, well, she didn't say this and now she didn't want to testify. Like he's saying that kind of clashes, because if she didn't want to testify, why would she then choose to testify and lie? Because if she would testify and lie because she has a bias, then why would she not want to testify? So if she has motive to display bias, why would she then not want to testify? Like that's really what the judge got him caught up on, and he does not know how to answer that.
Just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Bro, just get to the vagueness.
Next, Terrence Bradley, and
Jesus.
I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. When Mr. Sadow, why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand
I ain't really question Fani Willis like decision making, even when it came to her being in a relationship with dude. Like she had a right to do that. I'm questioning her decision making by having this nigga represent her. I'm gonna keep it a sec. This is too big of a case for this type of performance.
The relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced
No
to the
charisma.
court, the statements that Mr. Bradley made,
No
the statements
style.
contained are
It's not
inadmissible
definitive.
hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that, he was expelled or exiled from a thriving law practice. And it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge, basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip. And this is, Your Honor.
The question I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
Yeah, she didn't come out with none of that.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis.
Okay, you getting somewhere now. Just sound confident saying it. Jesus.
The testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation because it asks, do you think it started before she hired him? And he
it's
says,
harder
absolutely.
to listen to the state than it was to listen to Trump
any
supporters.
Context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court as to a lot of things, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley, and I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially and I'd even say direct as to that conversation not existing, because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist.
Okay.
Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned.
He
into,
doing better, y'all,
dating
but his
between,
performance is ass. His
the district attorney
argumentation.
and Mr. Wade.
I mean, it's
What he
actually they
testified
just
to
have
is that
the
he
evidence
moved
to
into her
prove
South
this
Fulton
stuff.
home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South. That is,
And they got a
Ms.
typo.
Willis.
How you got a
he
typo?
Made clear that he lived in that home
nervous,
with Miss Willis and Miss Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Miss Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Miss Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times. He said, in reference to the questions by defense counsel that were in a...
Yeah,
and I'm just going to be straight up with the court. They were trying to make Miss Willis a liar. What is how I would submit to the court, in the sense that
be clear,
she
be
testified
definitive.
that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Miss Willis, but failed. Would be how the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office. And he talked about how he kept cash in his home and why Miss Willis kept cash in his home. And what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. So
give him a grade. How would y'all grade the state attorney right now?
Mr. Floyd only did so due through his preparation with the state and his hearing and seeing
I get a nigga like a D.
news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it, and did it follow her, where she laid her head, and things of that nature, trying to further
Peaches give him a
discredit
C.
the practice that she had as it relates to keeping cash in her home, and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard
I
from
pray he not the
Governor-
only
former Governor Roy
attorney.
Barnes, and his testimony was significant and important because
Joe says
I
C
would-
minus.
how I would phrase it, Your Honor,
Yeah,
it
nice.
debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the Wade is currently filling for the state of Georgia, which is the
At
lead
that
prosecutor.
time as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor lead the
Come on.
investigation,
Come
which
on.
led to the ultimate
This is like
prosecution.
a pet peeve
we're
of
here
mine.
before Your Honor,
Like,
today. He
when it's
also
something that
indicated
can
that the reason
just
he
be
turned that job
said,
down
and it's like a
was because
struggle.
it
Like,
didn't
it's
pay
like,
enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards, because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks, in addition to Mr. Wade. If she has this grand plan scheme in order to profit off of the prosecution of this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that
this
Mr.
would
Barnes
this
and
would
Mr.
hit
Banks
way
would
more
turn down
harder with a much
so she
better
could then
speaker.
hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to
Trying to
that.
make sure we know exactly what is in the evidence and is not, but regardless, I think your point is made.
I think it's an evidence of the record as it relates to
The testimony.
I guess the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide.
Krishar
is
said, "I've
just,
come in late and
chart
could tell
showing
he is
kind of
dropping the
testimony
ball."
of both,
Yes. I mean,
the
he's making the
district
right
attorney, Ms.
arguments,
Willis and
but
Mr.
he's
Wade,
not doing
as
it
relates to how
persuasively
they
at
met,
all.
how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation.
See, he
It was
has his
false.
moments.
She
He
said
has his
she had
moments.
no information. She was asked about trips. She said she had no information.
This is a good
about
moment
the
for him.
trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continue to be in a relationship in 2020, 2021, until their relationship ended due to her forced resignation and I guess splintering of their friendship, Your Honor.
If this nigga say, "I guess," one more time.
I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Miss Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were Defense Exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did, in fact, pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who The state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court.
I don't know, y'all.
You heard about
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely, but we use them with an expert, and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about them.
No. Focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that?
Bro, this is easy.
What I would
The cell
say
phone records is
initially
easy.
is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer-reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates, I believe it's September 10th and 11th and November 29th and 30th, the affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville. Because again, during the hearing, the address for the Yurdi condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now, I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't, let's see. So what's interesting is that the records that were provided were they started in January of 2021.
So now he's about to get into
I believe it's to
the cell phone records.
November 30th, I think is what of 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdi, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move.
Okay.
The assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home.
So the cell phone records actually work against the defense in this
context. Been in a
context.
relationship as they claim
for
all this time, but never once
went
to the house. So I think that's telling.
They data corroborated that he never been to her South Fulton home.
From January of 2021 to March of 2021, those times when Ms. Willis did not live again at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure. How do you reconcile that with his testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
would those line up to 23 times? I think,
Well,
They didn't give it too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Miss Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And I guess after Miss Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Miss Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Miss Willis and Mr. Wade was that he had never laid his head, was the direct quote at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to
Yeah, Chris Shaw, he's starting to pick it up a
if you
little
were to
bit.
give credence to what the non-expert says,
He's just like he
as it
keep
relates
hitting
to,
road bumps.
Mr. Wade's handset
Speed bumps.
in September and November for the 3 to 4 hours that the phone is alleged to have remained. That doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, I guess the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood.
Like, it's like having all the right
cell phone
tools
records
and still just like not
in
putting
an
it
area,
together right.
and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you're close with, and the number of times that you make calls to any of those people.
Fani should have hired me.
Submit to the court that I have a friend who I've been friends with for 15 years, and she worked in the office previously with me.
I need some definitiveness,
and based on our professional relationship and our personal relationship,
I need some
the friendship that we had had and still have, that we talk 30 times a day. So that doesn't mean we're in a relationship. So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house. that her home was vandalized. And there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety and her life is something that was testified to. And the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence and were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from at HBCU. But what's been leaked to the media is the fact that she
got kicked out of FAMU,
flunked out of school, and someone other than her father moved her, which again, the validity of which was never shown. And all the while,
that nigga was gossiping for real. How you gossiping
Ms. Willis
about that
facing
woman,
these
dog?
costs has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from.
Bro.
Stretching out the case, for lack of better words, by
Who goes in the court and says,
the
"I
special grand
guess"?
jury recommended that
Be
39
definitive.
individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large scale cases like this one and much larger. And they also have, there's a lot of high profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and
I'll be staying
assertions
at the
that
DoubleTree.
Miss Willis was living the lifestyle of the rich and the famous is a joke, absolute joke. As it relates to what you heard.
Forensic
and
misconduct. Get to it.
Secondary issue is the forensic misconduct. And for lack of better words, what it has to be shown is that the statements that were made by Miss Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to Your Honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate in the previous year that she was serving as the district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Miss Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which
they reaching
this
for
is
sure.
an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis, and it involved a statement that the words fake electors were said by Ms. Willis, and he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding to comments made by Marjorie Taylor Greene and Bridget Thorne, two other political officials, therefore making her comments not even close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic
This is where I
misconduct
want to get it goes, especially. Like, you ain't about to say she detracted and did this and did that to mess up the case. But y'all been putting all type of shit in the media.
And I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was
he
at all
ended up
the
being
result
on
of
track.
political bias, which has been
He mentioned the right
accused
arguments.
or accusations
His
have been made,
execution was
as well
ass,
as
though.
demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. what I would leave the court with, kind of how the state started the argument, is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we would respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
Sheesh.
All right. Thank you, Mr. Abadi.
All right, so we got a 5-minute rebuttal upcoming.
5 minutes and 44 seconds.
That's what it says. Mr. Cromwell.
So
I'll
this
leave
is-
it. Oh, you, okay, handing it over. Understood. Mr. Sadow, all yours.
Now say that I was Trump's attorney. Trump's specific
I'm going to
attorney.
do rebuttal, specific rebuttal. One, the state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. Its counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take, as disingenuous as it can be. Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand. But as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done. Second, let's use a little
They was
common sense here.
objecting their ass off.
Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that
I'm sorry,
case
say
here?
that.
Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. The state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty.
Why
but
can't she talk
they're
about race?
racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever. The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade. And let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis. Not a soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville, they didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony?
But
Who
she
else
said
was
she
there
seen it.
besides Mr. Wade and Miss Willis?
According
Both of them
to y'all,
agreed.
Miss
No
Yodi.
no one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew.
Yeah, this
no
shit
one
disrespectful.
knows except who? The one person that knew was Bradley and Yerty. Yerty was best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now, the only way that the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully,
We almost done, y'all.
every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do. And
All right. Thank you, Mr. Sato.
All right.
There it is.
There it
All right.
is.
Thank you, everybody. I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks.
Damn.
Until that point, if there are any other issues that come up, council can reach out and we'll have an order posted on the docket. Thank you all. We're off the record.
All right, and that's it. That's it. The disqualification hearing has come to a conclusion, and the only thing we have left is the decision, which sounds like it'll be in a couple weeks. It'll be in a while. So, few things. Very disappointed with the state. Like that shit was hard to watch. I'm not gonna lie to you. And in debate we call it debating down. When you have an opponent like the defense who are really clearly grasping for straws. They're talking about everything they can to make to combine as much circumstantial evidence, as much conjecture as they can to create a conflict of interest, or even to create the appearance of a conflict of interest. And the state was equipped, like even with those slides, the state was equipped to provide. I mean, I think the slides spent too much time on certain things. The state was clearly in a position to provide all the necessary answers and rebuttals to what was going on. But they like how an argument is delivered provides just as much credibility, you know what I mean, as like the foundation of the argument itself. If you're not clear with like what's important and what's being said, right? Like, with language, there's certain things that we articulate more so we can make sure, it's being understood. It's certain ways that we frame what it is that we're trying to say. To make sure that what we want to get across is getting across. And there were huge moments where there was things that he was trying to say that, like I said, made me cringe, because it's like, I wish I could say it for you because it's so easy. what needs to be said is so easy. You know what I mean? I do think though I'm less confident. I still don't think she'll be removed, but I'm less confident than I was before the state spoke. I mean, because I'm a debater, and this is like actual law. Or I debated and I coach debate, and this is actual law. So how? But I think though the question of how persuasive the argument is relevant against all. You know what I'm saying, amongst all activities like these. It's all relevant. So yeah, I think it's. I don't know, like it was just kind of odd, like how like this brother got up there and just sounded so amateurish, like he just sounded straight novice, and I don't think it did the state's position. I don't think it did it any justice. Like I feel like the righteous rage that we saw from Fani Willis should have framed how the state did their final arguments. These is last arguments. Now, this is just what the judge sit with. Now, I do believe that the judge is going to take the arguments that he understood. I think it's an opportunity there for him to sit with and just more so focus on the facts outside of like how it was delivered. But I think we'll be lying to ourselves if we say that how information is delivered doesn't play a large role in how it's received. And so I think in this context, and like it was not received well. I don't think he was received well. I think there was certain spots where he made the right arguments, and other spots where it was like, like I for example, I think when you're going to say that they're mixing up the different laws together to try to make it seem like it's something that it ain't, I think you should be able to at least have some clear examples to where you say, you see how they're saying this, but they're combining it with this. I think that portion could have been articulated better. I feel like the whole case law portion was mid, because when he was asked about certain things, he sounded very confused, right? He said he did not sound like he was clear on certain case law, which is like, I mean, and when the judge got to ask you, like, give him an example of how they're misinterpreting the case law, how they misunderstanding the case law, you got to be more clear about that. And a lot of his explanations used a lot of words. And this is the state. A lot of their explanations used a lot of words, but didn't say shit. Like really, it was similar to when Ashley Merchant would ask a bunch of questions and not go anywhere. Like that. Like this dude was the equivalent of the state, or of Ashley Merchant for the state, the weakest link. And having the weakest link do your final arguments, I don't know. That's kind of a little bit questionable. Yeah, I feel like I haven't questioned Fani Willis' judgment at all as it pertains to any of this. Even when it comes to her relationship, fuck who you want to fuck on. All of these white people are doing it, and it's not impacting their ability to do whatever. You know what I'm saying? Like even like Rudy Giuliani was a whole perv. You know what I'm saying? It's somebody that he worked under, and it didn't change anything. So yeah, I mean the state still came, or the defense came with the same bullshit arguments they was running with. They tried to make a big deal out of a lot of things that weren't very clear. They had a lot of circumstantial shit, but nothing definitive. Even their witnesses were very vague. I think Terrence Bradley did nobody any favors. But what I can say about the defense is what they did is they were definitive in their statements. When they said that they were lying, they were definitive. There was no I guesses. The attorney for the state said, I guess, at least 6 times. Everything is they're lying, they're unethical, it was very clear. Which I don't know if it just kind of speaks to their experience or whatever, but the state was very clear in the characterizations that they were putting forth, while the state was just kind of like, I think this is it. Like it was all these pauses as if he was unprepared. Like nerves is one thing, but I feel like that, it felt more unprepared than nerves. But with that being said, we got 2 weeks. Before we find out. So here goes nothing. You know what I mean? We'll see. Like I said, I am a little less confident than I was coming into it, and even after listening to the defense, I was like, okay, they better get up there and cook their ass. So this was disappointing, but thank y'all for joining me for the conversation. Y'all make sure y'all follow me on TikTok. I'm posting all the updates on everything on TikTok. I'm probably about to go ahead and make a video about how disappointed I am with the defense or with the state in this context. But we'll see. Appreciate y'all joining me. I'm out. I'll see y'all next time.